The topic here we have for panel 15, come on in please, is reforming the multilateral trading system, dispute resolution and negotiations. We believe it will be exciting but that's our belief, the panelists and myself, and it's up to you to have a take on it, and we wish you would enjoy and learn and benefit from this. So I'm Suresh Nanwani. I have with me 5 eminent speakers, and I certainly want to stress the word eminent. They have all presented before, either by presenting at previous conferences or through publications in other ways, and are now further sharing their knowledge and findings on the topic. There is in the panel, as I mentioned, 5 speakers. On my right is Moshe Hirsch from Hebrew University of Jerusalem, followed by James Losari, City University of Hong Kong, Anna Perez on my side here, University of Bristol and University of Sussex, UK. And then we have Carmody from University of Western Ontario. And last but not the least, Ronjini from CTIL in India. So without further ado, we'll start off first with the first speaker, Moshe. His topic is on legal culture. So I want to accentuate the various aspects of the panel topic, which is on legal culture. And Moshe, the floor is yours. You have 9 minutes.
Thank you very much. Hello, everyone. Since I'm just at the beginning of the research project, so any comment will be most welcome. Let me start with the crisis in the WTO dispute settlement system. I guess that all of us here are well aware that the appellate body doesn't function, and because of that, the EU and some other WTO member states have established the MPIA. Currently, there are 53 member states of the MPIA, and the first award was delivered at the end of 2022. So in this research project, first I would like to identify what are the main elements of the legal culture of the MPIA, and then to analyze what are the main consequences of this legal culture for the future development of WTO law. And just to clarify, when I say legal culture, it is a much broader concept than the formal legal regime. I mean, here we take into account not only the legal provisions or the decisions, formal decisions of the tribunals, here we also examine widespread practices or norms prevailing in the particular legal community, rituals, and the social background of the adjudicator. So there are two main legal cultures that are relevant for the legal culture of the MPIA. First, we have the culture of ad hoc arbitration. And ad hoc arbitration is generally characterized by strong private features and contractual features. On the other hand, the legal culture of the affiliate body or the previous affiliate body, it was deeply embedded in the organizational culture of the WTO itself. So after examining many features of the legal culture of the MPIA, I'm sorry that I don't have time to talk about them, only about few examples, it is quite clear that we have here a hybrid legal culture. For example, there are some prominent features of the arbitral culture. For example, parties' consent is very important here. Of course, in the MPIA, we don't have compulsory jurisdiction. Yeah? The parties are not bound to come to the MPIA unless they agree. Or let's take another example. From the first decision of the MPIA, issues of judicial economy were emphasized. I mean, the fact that this one or two, depends how you count, the decisions, they were delivered within short time frame, less than 90 days, much shorter hours, which is quite impressive achievement. But if we check many smaller or subtle features of the legal culture of the MPIA, we can see that they strongly resonate with the previous legal culture of the body. Let's take some or three examples. First, with regard to the arbitrators. They are not selected, they are not paid by the parties, but rather by the WTO itself. When MPIA arbitrators encounter questions that are not answered in the MPIA rules, procedural questions, they have to apply mostly the rules of the former appellate body, or with regard to rituals. Let's take the example of rituals of hearing. They are so similar, they are sometimes identical to the legal culture of the appellate bodies. And I can later on expand. There are so many rituals. And there are, of course, some features of the legal culture of the MPIA which are somewhere in the middle. For example, we have secretariat support. It was quite a controversial issue. We have it, but it is reduced. There is a reliance on previous reports of the affiliate body, but it is reduced. Yeah. And overall, I'll present some very initial conclusions. First, with regard to lacunal and vague provisions. And of course, there are many cases with vague provisions. Seems to me that MPIA adjudicators in such cases, they will go almost instinctively, many times, to the background culture of the affiliate body or its social norms. Just one example, with regard to the norm that has been developed within the affiliate body culture with regard to rare dissenting opinions. I won't be surprised at all if MPIA tribunal will continue with this norm. But I'm not saying that MPIA tribunals will continue the same as it was with the appellate body. It is true that cultures are slow to react, but we know from our experience that once we have some crisis, legal cultures, they respond rapidly. And here, no question that we have real crisis, and it's not only a crisis in the system of dispute settlement, we have a sense of crisis or trauma in the WTO community in large. And it seems to me that we have some social expectations, or I would say something like social pressure imposed on MPIA adjudicators not to exercise judicial activity, to be much more restrained. Yeah? And let's take just one example with regard to the standard of review. Yeah? We could see that in the first decision of the MPIA, the standard of review has been lowered. And my impression that it would be spillover, this lowering standard of review, not only in the sphere of anti-dumping, but also to other spheres of the WTO law. And now, finally, two small issues with regard to developments within the MPIA legal culture. First, there is a question that arose in literature about the precedential value of MPIA decisions. And the question here is whether future MPIA tribunals will be constrained by the first decisions of MPIA tribunals. I believe it significantly depends on the social cohesion among the 10 MPIA arbitrators. And if indeed we are going to have more MPIA proceedings and they have a lot of social interactions among them, we are likely to see more social cohesion among this group of 10 arbitrators, and it needs more peer pressure among them to conform to these MPIA techniques. And finally, I'll stop here. With regard to the emergence of sub-legal culture, because the MPIA rules allow the parties to modify the default MPIA procedural rules, I won't be surprised that we will have some model of the EU, like in bilateral investment treaty, that we have the US model, China model. So I won't be surprised at all if the EU would develop its own template, similarly China or Latin American countries. And I would just end by saying that generally I believe that pluralist structures, they are very good for some reasons. But we must bear in mind that they are much more susceptible to the influence of the more powerful trading countries. Of course, it's not Israel. Thank you.
Thank you, Moshe. The next speaker is James, and his topic is on two central themes, reimagining and a bipolar world. So without further ado, I invite James to go ahead.
Thank you. It is my pleasure to be here today to present research that I'm working on. So this is still a preliminary stage, and I would really welcome any kind of feedback and comments from everyone. So the research is really about, and the title of the paper that I'm working on is Reimagining the Trade Dispute Settlement Mechanism in a Bipolar World. I'm trying to ask what sort of an ideal dispute settlement mechanism that can work for the US and China. And the background of this research is really based on the current relationship between the US and China. Yesterday, I think the roundtable discussions and across different panels, we have heard a lot of explanation about the US-China relationship. Experts have voiced their views on what is the existing relationship like. And what I want to do here is just to summarize some of these relationship characteristics, where there are two major superpowers, and with China as a rising power. And Professor Schaffer explains this as a clash of power, values, and capitals between the two. And of course, trade war is one of the main areas on the relationship, the tensions that is rising between the US and China. We heard about the recent Chinese government's measure on export control on certain minerals. So all of these actually gives you a picture of the US-China relationship and tensions. And Graham Allison explains this in his book, Destined for War. Can the US and China avoid war or escape the Thucydides trap? So what he explains there, Thucydides trap is really a dangerous dynamics where there is a rising power that threatens to displace the incumbent power. He suggests that there is a likelihood of war is happening. And he looked into 16 different circumstances and cases in the past, where in 12 of the different cases, actually there was a war that happened, but in 4 different cases, it was managed quite well. So what can then be done to prevent war? And this is what some of the suggestion on how you can escape the Thucydides trap. Among others, yes. So building trust, avoiding the use of force, reduce misconception, extensive cooperation, and managing expectation. So from all of this, to a certain extent, I believe that dispute settlement mechanism can actually contribute to some of these factors. And for that reason specifically, I'm looking into the dispute settlement mechanism in the realm of trade, because trade wars is essentially one of the main areas of tensions between the US and China. So I think it is a critical area where we can actually ease the tensions between the US and China. So let's take a look at the trade dispute settlement mechanism that is existing between the US and China now. At a multilateral level, of course, we have the WTO dispute settlement mechanism that loosely said it is partially functioning in light of the Apple crisis. I will not explain further about the Apple crisis because a lot of experts have extensively elaborated on this issue, but what is really happening is it happens because of the US criticism against the system and leading to the blockage of the appointment of the new appellate body members. And as a reaction, I think Professor Moshe already explained how some member states decided to go in and enter into the MPIA as a way to avoid appealing into the void. But the US is not part of it. And so the question is really, but even though the US is not part of it, what we see, the US is not entirely against the idea of arbitration, because we could see in DS 548, when it deals with the European Union, eventually the US entered into an arbitration agreement with the European Union. So there is no dispute settlement mechanism at a multilateral level. On a bilateral level, we see, and plurilateral level, there's also no trade agreements between the US and China. There was, of course, the phase one agreement, but about that, it is not as comprehensive. So in light of all of this, there have been many comments and many suggestions on how we can further reform the WTO dispute settlement mechanism. I will not go into these proposals, but what we are seeing now, there's not much movement from the US side to actually agree on these proposals. Of course, China is quite supportive of the idea of reforming the WTO DSM, but the US is still not there. Then what can we do about the US-China tensions? Because I think the main objective from what I'm looking at in my paper is really to avoid war, to ease the tensions between the two. So my proposed trade dispute settlement mechanism that may work between the US and China is that a non-binding dispute settlement mechanism. Well, the question is, of course, the DSU has provided that. We already see even a mechanism provided under DSU, but what I'm suggesting, this is to be done on a bilateral level between the US and China. Of course, the idea can be quite provocative, and I would like to welcome some comments on this. And what I'm suggesting, what is different from the mechanisms under the DSU is the fact-finding process and access to the fact-finding results to the WTO members. In a way, this could enhance transparency and at the same time, try to uphold multilateralism at the same time. And the procedures that I'm suggesting, I call them consultation plus as well and mediation plus, without excluding the option to go through the WTO dispute settlement mechanism as well. So what is consultation plus and mediation plus? Well, as I mentioned earlier, the main key feature is really the fact finding. It is a modified consultation process as compared to Article 4 of the DSU, where here you have a fact-finding process that is similar to that trade policy review mechanism in the WTO now. While it partially offers some transparency where the fact-finding result will be shared among WTO members, but it still allows bilateral confidential negotiation to happen between the US and China. And this fact-finding mechanism can be very useful to really shed light on what is really the issue, what is really the concern of the two countries. And there are two main documents that will be involved: policy statement of the respondent and detailed report of the measure, as in the case of the TPRM. The other mechanism is mediation plus, and this is also found in the WTO under Article 5, but with a fact-finding process. And I believe that this can be more useful for disputes involving complex issues where having a mediator to assist in the resolution of the dispute can be helpful. But the difference with the procedure under the WTO DSU is that I'm not suggesting a sequencing procedure. You do not necessarily have to go through the consultation and the mediation. So China and the US can agree whether they want to go directly to mediation if they feel that it is actually more appropriate for the relevant dispute. Well, there are, of course, some challenges and potential questions that might arise. Why do we really need the DSU plus mechanisms, the consultation plus or the mediation plus? Well, what I could think at this point is that the US is very skeptical about the current DSM at the WTO. Hence, providing a fresh alternative could actually be something that is good for further consideration. Will the US agree to the fact-finding mechanism? I think it is not clear, definitely not clear, but given that the US has participated in the TPRM process anyway, then there should be less concern for the inclusion of such fact-finding process. But the challenge is, I guess, I set out three here, whether we will do it within the dispute settlement understanding, because as I said, they are quite different than what is found in Article 4 and Article 5 of the DSU. So it is not fully compliant in a way. And secondly, there's a concern that if it is done on a bilateral level, the DSU is a multilateral instrument. So how can we really facilitate that? And the other challenge is, of course, the confidential nature of fact-finding. Will the US and China cooperate when they have to go through the fact-finding process? I think there must be some difficulty, especially when we deal with issues relating to national security, for example. And the last one is really to obtain the political will from the two nations. I believe that there have been a lot of efforts from the two countries to actually come together and sort of ease the tensions, as can be seen from several visits by US high officials, the president, as well as the recent visit of Yellen to China. But whether they will agree to a bilateral arrangement like this, I think we will have to see that further in the future. Thank you.
Thank you very much, James. As you can see, comments are invited from the audience, so please plug in during the Q&A. The panelists would love them for sure. And the next speaker is Anna, and the keywords are transience and informality, with a twist on informality. It's IN in parentheses. So here goes, and Anna, the floor is yours.
Thank you, Suresh. It's a pleasure to be here as a Brazilian national to be talking about the WTO Latin American. Couldn't be happier. So, contrary to my fellow speakers who have been focused on dispute settlement in the WTO, the focus of my presentation is on negotiations. After all, one of the reasons why we have the appellate body crisis nowadays is because we have a deadlock in the negotiations, right? So I think that speaks for the importance of this topic. And this paper that I'm presenting today is the outcome of my doctoral research. And I'm currently working on a book proposal based on this argument, so of feedback would be welcome. And I started my analysis here based on two main questions. So first of all, how do WTO members negotiate? And second of all, how can the WTO be relevant in the current context, the current geopolitical context? And again, talking about the relevance of this, right? So when you're talking about reform, you need to think about what type of reform we are talking about, we are discussing here. So if we look at this institutional reform or formal reform, as I say, formal and informal here, we are looking about a rather burdensome process where we need the agreement, we need the consensus of 164 members to change the rules of the WTO. So you can see how difficult it is to reach that, right? So what I propose here is, bear with me, a very radical idea, looking at what members are doing now. So members, they are negotiating, they keep negotiating, they keep updating the existing rules in the WTO. So what my focus here is look at the practices developed by members. So you can see here that the WTO law and the WTO itself evolves through practice of members. So how members interpret the WTO rules and how the members apply those rules. So what we have here in the WTO, yes, we have this regulatory and institutional framework. So we have the WTO rules, we have different bodies, different committees regulated by the WTO agreement, but also we have this other side of the WTO. So the WTO offer members, the existing rules, they offer members flexibility to address new demands or new needs as they arise. And members, they do that through practice. So yeah, my main argument here is based on the transience of informality. So what I'm proposing here, there's this intersection of dialogue between formal and informal processes. So they are not mutually excluding, but there is rather this dialogue. So for example, the consensus rule that we have nowadays emerged as a practice during the GATT, and it was formalized in the WTO agreement. Whereas when you're talking about critical mass, in the 90s, we have the telecommunication paper and the ITA agreement. And almost 30 years on, those practices were not formalized in the WTO. So you can see that it's not necessary for these informal practices to be formalized, but they can trigger these substantive outcomes, as I mentioned, those two agreements. So here, what I'm suggesting, right, my idea here is based on this notion that law is much more than formal sources or formal mechanisms. So the WTO agreement allows for this flexibility for members to develop new rules or new understandings based on the existing rules. So again, we should look at the practice of the WTO, and we should look at how members are interpreting and applying existing rules. And such practices, they are triggering this silence reform of the WTO. So we have here a big shift, especially if you look at the medium and long term span. So the decision-making system, right, is being reformed by members. And here, following this reform by doing it approach. What I find here, I've been talking a lot about informal practices, informal mechanisms, but what are those processes? So you can see here in this slide a few examples. So we have here a wide range of different instruments. I mentioned critical mass, but we also have coalitions, the G20 in trade G20 in the early 2000s. We have informal meetings. For example, the Green Room and how it evolved, this idea of informal meetings evolved to that in the WTO. And more recently, we have the joint initiatives, which is my focus here in this research. So my case study is specifically the joint initiative on investment facilitation for development. So for example, on this, we have first, in 2017, during the Buenos Aires Ministerial Conference, members, they agreed on this joint statement, which for the co-sponsors of the initiative was enough as a negotiating mandate. But we had here some opposition, right? India and South Africa. So they still argue that the co-sponsors, they don't have the negotiating mandate for that. And after that, we have what members call the structured discussions. And after that, we have negotiations. And last week, members agreed on the text of the investment facilitation agreement. So you can see here also, for example, members, they created a doc number for this initiative. So there was nothing in the WTO that could allow members to have documents in the website for the files of the WTO. Members also, they require the assistance of the Secretariat. So the Secretariat was acting on behalf, on request, of the members. So you can see here again how formal and informal aspects of the WTO, there's this conversation, right, between them. And yes, thank you. I'm almost done here. So we can see that this initiative offers us then an idea or an option, right, how to move forwards in the WTO and how to reach consensus building and how to reach substantive outcomes in the WTO decision-making process. So what I think members should focus now is how to improve these practices. So how to make them more transparent, more participative, more inclusive, and also how to link the outcomes in the WTO to the WTO structure. So I think talking again about the investment facilitation agreement, I think that's going to be the biggest challenge. So members, they announced that they are aiming at having a multilateral agreement. and they want to do that by February 2024, which is the next ministerial conference. And I think that's a huge challenge because again, they need to convince India and South Africa and the United States as well. So yeah, I think that's going to be a lot of work for the next 7 months. But I think this gives us, provides us a good example of, it's also a good exercise to think outside the box, and not only for members, but for academics as well. So we have, for example, the International Trade Center, they have initiatives to think about, right? They're holding events to think about how to link these agreements. We have the one about domestic regulation, right? They linked it through the schedules, but here for investment facilitation would be a bit more difficult because it's not only about services. So I think this also offers us a good opportunity to think about what is the place of these rules. And we've been talking a lot in this conference about binding rules and soft law, but I think between these two ends, there is lots of possibilities that we need to explore as well. And yeah, my final remarks here to conclude. So I think that we need to look at the evolution of the WTO. We need to look at what members are doing, and members they use law to legitimize these practices. So law, instead of being this form that's very rigid, we should use law to legitimize members' actions and practices in the WTO in order to keep the WTO relevant and to keep delivering outcomes, right? To address urgent needs. And these informal mechanisms operate inside the formal framework of the WTO. They can provide the needed flexibility and participation. Again, the main goal here is to deliver substantive outcomes. Yeah, that's it. Thank you very much.
Thank you, Anna, with the radical ideas and the options. Next is Kai, and his topic would be focusing on two key themes, which are precedent and possibility.
Thank you very much, Suresh. My name is Kai Carmody, and I'm an associate professor at the University of Western Ontario in London, Ontario, Canada. And it's my great honor to speak to you today, and quiero decir unas palabras en el idioma de la gente colombiana. Gracias por su bienvenido aquí en esta tierra de sabrosura. So I came upon this idea of precedent and possibility, really in looking at the ideas behind this particular panel. We're looking at dispute settlement and dispute settlement reform. And what would dispute settlement and dispute settlement reform mean for the notion of precedent? Precedent is important as a preliminary matter in WTO law because we have this concern with deciding matters subsequently decided in the same way that they've been decided in the past. And we know from the statement in DSU Article 3.2 that the dispute settlement system is supposed to be characterized and supposed to contribute to security and stability. And key to that is the idea of precedent. Now, the ideas I'm going to be speaking to you about very briefly this afternoon come from a recent book, which I'm going to make a shameless plug for, A Communitarian Theory of WTO Law, which is forthcoming from the Cambridge University Press, which sets forward some ideas that I have about the nature of WTO law. What is the sort of structural nature of WTO law? And the way I see it, WTO law really resolves into sort of two competing idea complexes. One of these idea complexes advances the notion of equality and is principally driven by the idea of obligations on states. It's primarily structured in a constitutive fashion or constitutive form. It looks forward, and it's reasoned principally by means of presumption or inference, so deductive logic. There's a second idea complex at work in WTO law as well, and this is primarily concerned with fairness or what is appropriate in given circumstances. And this appropriateness is driven home by the exercise of rights. And this exercise of rights typically takes place by means of contractual structures, like we're seeing a lot of today. And this contractual structure is primarily backwards looking, because when one asserts rights, one has to have a right, and that right already is pre-existing. And that right is determined by virtue of evidence. Now, it's easy to think about these two idea complexes sort of as caricatures of what the law is. But the reality is that WTO law really is a mix of these two. In real time, the two different idea complexes are working together. And I'm suggesting in this book that what we're seeing today, rather than what perhaps we might have spoken about in a conference like this 25 years ago, what we're seeing today is really a preoccupation right now with rights and with the exercise of rights. Why is that? Well, there are a number of things that sort of drive home the emphasis of countries today to exercise their rights. I mean, in a conference like this, we begin our sessions yesterday with a look at Article 21 of the GATT, the National Security Exception, which is a classic indicator of what rights are. And there was a lot of hand-wringing about what the rights are and how far those rights can be examined. And I'm suggesting in my book that really the basis for this concern with rights is underpinned by a sort of diminished sense of interdependence, diminished belief in interdependence. It's a good, and a sort of shift towards a diminished sense, therefore, of community. And in this diminished world of community, what we have then is a sort of growing concern with rights. And along with that concern with rights, a question about the particular role of prior decision-making, the extent to which that prior decision-making should somehow constrain our ability to exercise our rights. Now, in WTO law, it's classically the case that there is a sort of tension in WTO dispute settlement between, on the one hand, WTO dispute settlement is a sort of lawmaking function. And secondly, the idea of WTO dispute settlement is a function that's really set up to resolve disputes, to resolve particular disputes. There's a third element, however, that comes into all of this, though, from DSU Article 11. And it's this idea of the panel making an objective assessment of the matter before it. If it's to make an objective assessment, that idea suggests that if facts are changing, then in fact what has to happen is that a panel has to have some leeway to depart from prior precedent. And these ideas are important because if we start taking a look at the doctrine of precedent in WTO law, we see this statement, a very famous statement from the appellate body in Japan Alcoholic Beverages in 1996, about the fact that, formally speaking, panel reports are not binding on subsequent panels, but they do create legitimate expectations. Then we have this sort of reformulation of that statement in the US stainless steel case from the appellate body in 2008, where there's a slightly stronger statement that comes forward that says that absent cogent reasons, a decision that's being made by a panel in a matter should be decided the same as it was previously. But that's in the zeroing context, where you have very, very similar factual situations. And it also plays into some tension, or there is again some tension there with this concern that is expressed in DSU Article 11 about an objective assessment, that each panel is making an objective assessment and should be allowed some leeway. Now, what do we have? Well, as was pointed out earlier by Moshe, in 2019, the end of 2019, as all of you will know, the appellate body suspended its operation. In 2020, we have this landmark report from the USTR, in which Robert Lighthizer and his crew says, there's no such thing as precedent, or certainly that appellate body decisions are not legal decisions, they're not law. And we have some echoes of this in cases like India, sugar and sugarcane, where both India and Costa Rica say essentially the same thing. There's no system of binding precedent in WTO law. So that's very interesting. And it's all very interesting because today, in the somewhat looser and more relaxed environment that we have, an environment of what I would refer to as perhaps not a system so much as more, I think we're moving more towards a regime or perhaps a network. We have a situation where different panels are starting to come to different conclusions. And again, yesterday, Senor Ramirez Hernandez was concerned about this. He said, look at the decisions on Article 21. 2 go in one direction and 2 go in another direction. And we have this disarray and there was all sorts of concern. I don't know if I agree quite with that. Where do we go with this idea of precedent from here? I want to suggest that The system, instead of sundering, seems to be moving away from a sort of common law idea precedent, where prior decisions have a strong relevance, to something that's looser and weaker. And perhaps in that, it's moving more towards a jurisprudence constante, thank you, where judges can look at, or decision makers can look at previous decisions, but not necessarily have to sort of take them as binding law. And I have sort of for this three then takeaways. First of all, I think the question of the precedential effect of prior decisions should be left undecided. I don't think we should really have statements about this by panels today. The matter should simply be left as it is. Secondly, it may be, and I think we're starting to see that the WTO system may be able to accommodate a fair bit of interpretive divergence, like we have in some instances in international investment law. And thirdly, I would like to point out that, there's all sorts of pluralism that could come about in the jurisprudence. And I think we have to recognize that this is a consequence of an insistence on a member-driven organization. If we have pluralism, then it is upon the countries themselves to sit down and try and iron out some solutions to this divergence, rather than lawyers getting themselves into knots about whether or not there is perfect consistency in this evolving system that now seems to be moving into something a little bit less directive, a little bit less normative, and perhaps a little bit more contractual and rights driven. And what I want to suggest is, as my previous colleague pointed out, Anna said, that the most remarkable aspect of the system seems to be the way in which the system is able to evolve organically. Notwithstanding the fact that we now have a lot of law, there's enough room and play in the system to be able to achieve a fair degree of certainly to provide a fair bit of guidance as to what to do and how to resolve particular decisions. So thank you very much.
Thank you very much, Kai. As you can see, we have at least 3 who have got publications along the way and inputs offline and online. We've got some who are offline participants here. Would be very helpful to all the panelists. And these can also be through offline after the session, or it can be through other means, coffee break, or if you have ways to reach them, please contact them and provide the comments through email, etc. The last speaker we have, but not the least, is Ronjini, and the key theme is fragmentation. And I think it's a fantastic way to end this session, because it's it's a very direct word, but having said it's direct, it's one of the important co-themes for this SIEL conference, the other being geopolitical confrontation. And for that, we've got James who articulated on that. So without further ado, Ronjini, the floor is yours.
Good afternoon, everybody. My name is Ronjini. I am from the Center for Trade and Investment Law, which is an organization based in New Delhi that advises the Ministry of Commerce and Industry of the government of India. To start off with, thank you, Suresh, and thank you, co-panelists. The word fragmentation has often been used as the F word in international law, and as somebody, as an early scholar who has not engaged with theory enough and struggles to engage with theory as an active practitioner, this was my attempt to theoretically assess the impact of the appellate body crisis. Now, why is the authority of the WTO dispute settlement mechanism fragmented? And the simple answer to that is because after the US blocking the appointment of appellate body members, the appellate body has become defunct, and the two-tier dispute settlement mechanism that was established by the WTO is no longer in place. Now, thereafter, members are all members through different ways, both through the WTO and outside of the WTO, are trying to address this aspect of the two-tier WTO dispute settlement mechanism not being in place. Now, this aspect is being addressed in multiple different ways. The first being the MPIA, which has been talked about a fair bit, and I see an MPIA arbitrator amongst our midst. And so the multi-party interim arbitration mechanism is within the WTO. It arises out of Article 25 of the DSU. So people do argue that it is a WTO inside the WTO mechanism, but not everybody, not all the members are a party to it. Key members that are not party to the MPIA is India and the US, that accounts for 4% and 8% of the global trade. Now, key aspects of the MPIA. Now, as Professor Moshe discussed, that we already have a recent arbitral award, Columbia French Prize, that has come out, which was the first MPIA dispute. Some of the issues that may be raised is, where is this authority coming from? Now, the MPIA members that are a fair bit of the membership have come together, but they are still being assisted by the WTO Secretariat. Now, the WTO Secretariat essentially is part of the entire membership, and not just the members who are MPIA members. The other example of this fragmentation of the WTO dispute settlement mechanism that I argue about is the non-MPIA WTO disputes, which is, so the Article 25 mechanism is available to all WTO members who are also not parties to the MPIA. So a recent example is the Turkey pharmaceuticals dispute, where Turkey is a non-MPIA member, but the EU is an MPIA member. And they had an arbitral award come out, where some of the arbitrators are parts of the MPIA arbitral panel, but not all of them are. So in terms of, this is another way. So the non-MPIA mechanism is available to all of the WTO members who are not parties to the MPIA. But if there is in case of a dispute with an MPIA member and a non-MPIA member, you have an option of trying to use the MPIA arbitral panels that are available to them. Now, the other aspects that are further fragmenting the dispute settlement is the informal interest-driven reform process that has been started by the US. And I think that I've heard a lot of my co-panelists have mentioned about the value of informal processes and how that does lead to engagement among members, especially in a defunct negotiating space of the WTO because of the consensus-based mechanism. But a lot of these informal mechanisms are non-transparent, are non-inclusive. And this informal interest-driven reform process that's being led by the US, there aren't even WTO documents that are available about this. As far as I understand, the US is trying to gather consensus among other members and trying to raise certain key issues that they want to drive in terms of the DSU reform process. Some of the things that I hear have even come across as to a check, like a three-tiered mechanism even. That could be considered. So these are further processes that are challenging and fragmenting the existence of the authority of the WTO dispute settlement mechanism. And the third and the fourth example that I consider is the EU measures that are being implemented by certain member countries, such as the EU, by virtue of their enforcement directive. The EU enforcement directive essentially ensures that members that appeal a WTO panel report into the void, the EU enforcement directive essentially applies countermeasures to ensure that those members comply with the panel report and don't appeal it into the void. Thanks. So essentially, these are examples that are creating to the fragmentation of the WTO dispute settlement mechanism, which as a young lawyer who was in law school thought of it as a near perfect system in international law of a two-tiered WTO, dispute settlement, binding dispute settlement system with compulsory jurisdiction. So now, what is the consequence of such fragmentation? So in my paper, what I try to argue is, even though the authority of such dispute settlement mechanism is being fragmented or reduced or being challenged by different members, and members are trying to follow different methods of arriving at the same conclusion, which is resolution of WTO disputes, the normativity of WTO agreements still continue to remain. And even though members are trying to, there are issues that are coming about when encroaching on disputes, they're still relying on the text of the WTO agreement. Even when there's a national security issue, for example, you're still relying on the text of the agreement. So the normativity and the degree of normativity that the WTO agreements hold still have value. Even though Jennifer Hillman did in last session say that the US is not particularly concerned about this, I do think they still, at the end of the day, have to justify the fact that they have not followed it, and thereafter their challenge and can be put to discussion thereafter. I have a couple of questions. These are open-ended questions, and I don't have the answers to these questions. But essentially, what is the future of the WTO dispute settlement mechanism without the appellate body? And it does seem bleak, because it seems like that system that it was so idolized for such a long period of time is disintegrating. And slowly, it seems like there are going to be differentiated systems depending on something that Moshe also indicated. There might be differentiated systems depending on the member states that are engaging on a particular dispute. So that was essentially my presentation. Thank you very much. I really encourage any comments on that.
Thank you, panelists. I wish to thank all of the panelists for keeping good time. I really appreciate that. I just want to sum up in terms of encapsulating the points that were raised, just to refresh ourselves. You would have heard them, but let's just give a brief, broad take in terms of the terms that they used, like precedent, or precedent, or in terms of bipolar world, etc. And here they are. We had Kai talking of panels slavishly bound by precedent, and then you had Moshe mentioning appeals mechanism binding precedent ensures consistency. So that was something that came out from him. And Anna, reform of WTO, costs and options and her radical ideas proposed. And then Ronjini, the future of WTO without its crown jewel. I like to postulate what is the next best set of jewels, as it were, if the crown jewels are not there. And is it bleak, doom, gloom, etc.? She articulated bleak. Could there be a ray of light that someone here might offer? And then we have James to strap. I think that concept has actually been viewed with skepticism by some quarters, like Joseph Nye, but it's still out there for the take. And you have, of course, it goes back to Sparta, the war at that time in the BC. And the telling thing was, and I found it really striking when he said, if it is not managed well, the war between the two nations, no prize who are the two nations, is not inevitable. That seemed to me to be pretty chilling in terms of geopolitics. I end on that note in the sense of just giving a brief overview of all the five here. And but now I open it to the floor. I think we have some online. Maybe you can just let us know later on, Alejandra. So let's go to the floor, and please introduce yourselves, your name, and ask your questions, and then I'll collect some. And then after that, we'll take a second round perhaps. Go ahead. So the first is ladies first. So there are two ladies in front of me, maybe the one in brown, and then the lady next.
Thank you very much, Julia from Humboldt University. Thanks. Thank you very much for the interesting presentations. I have a question that I hope does not come too much out of left field. But listening to these informal and formal institutional developments and what could happen or what is happening already makes me think of the normative side of things. So the question is for anybody who wants to answer. Do you think we also need a redefinition of the normative framework of the regime? So what are the collective objectives that the regime really seeks to achieve?
Okay, thank you very much. So the next lady can speak. I should have mentioned this is a question directed to a specific member or members or to this mention that. Go ahead.
Thank you very much, Suresh. My name is Daria Boklan. I'm from High School of Economics, and I have two questions, if possible. One is for Moshe with respect to MPIA. Yes, so on the one hand, MPIA is the kind of best possible alternative to the IB crisis. On the other hand, MPIA is criticized by different scholars. And my question, how do you assess the problem with enforceability of MPIA's decisions? I think it's one of the most practical and important problems. Also, we can criticize MPIA legal nature, but even setting this aside, how should we deal with enforceability of MPIA's decisions? How should we enforce these decisions? How should we deal with this problem? And the other question is for Anna. I also appreciate these joint statement initiatives because they're kind of a way out of WTO crisis, bringing different issues within the WTO context, like digital trade, investment facilitation, and many others. On the other hand, India has indeed good grounds to criticize these initiatives, taking into account that they are outside of initially agreed Doha agenda. So first we should finalize Doha agenda and then go to the other issues. And secondly, that they are not purely multilateral. How should we deal with this? But this is the other issue. My question is with respect to GSI that you specifically assessed on investment facilitation. How do you think we should implement this GSI on investment facilitation into the WTO legal framework as soon as not all provisions of this GSI can be implemented through, for instance, schedules of concessions? There are some provisions that require modification of WTO rules as such, and as soon as a couple of WTO members are against this initiative, how should we implement this specifically joint statement initiative on investment facilitation? Thank you very much.
I'll take a few more questions. I think Thomas Cotier had, and then the gentleman behind him, and then the gentleman right at the back is directly behind this. I see who wanted to be raised. I'll come to you first.
Thank you, Thomas Cotier, World Trade Institute. I just wanted to offer a few comments at the outset to stimulate the discussion. Let me start with the appellate body. I think we developed an attitude to put the appellate body at the center of the system. And so when it falls apart, the whole system falls apart. The reality is a different one. We see states using the panel system, including the United States, and we have been very successful in managing the adoption of panel reports without an appeal. To me, that's the success. So it depends very much on the perspective you take. And I would suggest just to move away a bit from focusing exclusively on the appellate body, but focus more on the ordinary panel stage, which I think is working, and to see what needs to be done there. My second comment would be on the MPIA. Moshe commented on this, and I wanted just to add one element which is really new. We are a team of 10 people. We had so far about 65 meetings online preparing this. And we also have a mandate of consistency, which is relating to the precedential issue. And so when a case comes up, we would have, prior to the hearings, we would have a meeting among ourselves discussing policy issues, not the case as such, but the policy issues in the case. And so we, for example, had a discussion on how to interpret Article 76 of the anti-dumping agreement. And then we leave the three arbitrators which are appointed by lottery to decide the case here. And that's pretty much what the appellate body did. What we introduced, however, is a new instrument which is the pre-hearing conference. So before we go into the hearings, there are two elements. First of all, there is an appeal letter which we send out, which gives instructions, including the page numbers they are allowed to give. This is a new element. This didn't exist. We are concerned with meeting the 3-month period, so we try to limit the issues. And the pre-hearing conference with the parties serves the purpose to narrow down the issues. We will tell them what we think is the important. And so they may refine and concentrate on some issues. And this is really a new element, which I just wanted to add into the discussion here. And how whether we will have precedents or not, that's really open. I would agree. We basically operate on the public international law system of precedents, which is the civil law system. So a panel is allowed to deviate if they have good reasons, and they should state the reasons. But overall, there's an interest of protecting legitimate expectations and legal security. So you would only do this with very good reasons. I also would like to make a comment on the idea of mediation. I think what we need to realize is that panels are brought in parallel to a negotiating process. You have a dispute, you negotiate, you bring a complaint to push the parties to move a bit. It's all with internal politics here. And these negotiations, in most cases, go on during the panel process here. And so it's not astonishing that we have never used mediators. The director general could do that, but very few cases happen that. And we have to be aware that when you're on a panel, this is in parallel to negotiations going on. And as a panelist, one must not be frustrated if the parties, when the report is finished, call the exercise off. For example, China, when we had the case on interpreting the protocol of accession, when China saw the result, they called it off. That's perfectly normal. So I think in the analysis, we have to include also the negotiating process of it. And finally, on the negotiations, I was working all through the Uruguay round, and I think what is really important, just as a psychological element, is the cohesion among the negotiating group. First of all, you need to know what the other needs before you come with your own claims. And you need to know your colleagues who are in the negotiating group, and you have to develop a lot of social activities, including weekends, to get this done. And there is a very good book about the TRIPS negotiation, which can help you to this effect. Secondly, I think NGOs are absolutely critical. NGOs like ICTSD, which no longer exists, had a bridge function between academics, civil society, and the trade community. And that is very important because compared to other international organizations like WIPO, the WTO is purely governmental driven. We have this world, the forum every year, which is allows the NGOs in, etc., but that's a fig leaf. They're not really involved in the negotiations. And I think that could make really a difference if they could have an impact. And finally, I'd like just to add that in a negotiation, you have a core group, and it's normally not more than 25 countries who really have a stake in it. So it's a wrong picture to say we need a consensus of 166 or 165. It's normally a smaller group, and you have to work with that particular group, and then you apply your recipes, which I think are very useful. So I just wanted to give a few comments, but the most important one is please focus on the panel stage and not disqualify the system by just looking at the appellate body or the MPAA. We are a success if there are no appeals. That's my dogma.
Thank you very much. I'd just like to just sum it up because you've given
social wisdom, set of ground rules as it was business segment shall read here. The effect that it makes to working with policy issues, regulations like engage, the NGO involvement and panel stage focus right here. May I just offer that perhaps if you can be so kind that maybe later on there could be some communication in terms of interview by the panelists with you if you're very trying to provide that. This will be really very beneficial for the panel itself. Thank you very much. And I think I'll just talk only now because I'm mindful of time. I want the questions to be answered for the first two speakers. So we've got first, Sophia, which mentioned anyone, redefinition of normative framework. So perhaps we start off and do it just 1 minute. If it's okay.
Sorry.
For you to answer and then we'll go down. Yeah.
I'll do it quickly. Indeed, the important question with regard to the normative dimension of the WTO law now, even without the appellate body, and I think here I will start with what Thomas Cotier said, in many spheres of international law, we do not have any courts and they function very well. It would be a mistake to believe that no court, no law. Perhaps just one example, international environmental law. Probably the most successful treaty is the ozone layer treaties. Wonderful, no court, nothing, yeah? And on the other hand, climate change is a disaster, if you ask me. Yeah? So in many cases, court is not the most important thing. I'm not saying that it is not important, but I don't think to say that if there is no court or appellate body, everything is bleak. I don't think so. And with regard to enforcement of MPA decisions, actually they should be enforced or implemented by the regular WTO procedures, which is also shows, I believe, that MPIA, it is quite embedded in the organizational culture of the WTO.
Thank you. Your 1 minute. Okay, that's okay. All right. Anna?
Thank you. So yeah, about the normative framework, I think definitely in the previous panel, we talked about what is the role of FTAs, what is the goal of FTAs, and I think we should ask the same question about WTO. So the WTO was an organization created in '95, and it was not a big break with the past. It was a natural evolution from a process that started in '47 with the GATT. So the WTO institutionalized this power, right? So you have countries, developed countries with structural power. And we have the WTO, the main goal was, largely speaking, market access, and the focus was on tariffs. And now we are talking about behind the border measures. So the investment facilitation agreement is an example. We talked a lot about environment in previous panels. Those are also examples. And I think if you keep claiming rules negotiated 95 to limit these initiatives, I think we're going to have a problem. So I think we definitely need to rethink the framework, the normative framework, and what is the purpose of the WTO, and what is the goal of the WTO.
Thank you. We have Kai and then Ronjini who will give their 1 minute speech.
Okay, so just very quick comments. I don't really see normativity as being something that can be usefully distinguished or separated or somehow segregated from the negotiating function. And that's, I think, in part why we're in such a difficult predicament. As Thomas Gauthier pointed out, I think the two really go together. And the fact that negotiations have broken down means that there was a lot of emphasis placed for some time on dispute settlement. If you had come to a conference like this 15 or 20 years ago, it would have been all about who's retaliating against who. And we would have had this, real emphasis on sort of, hard normativity. Today, nobody talks like that. And I think that's indicative of a realization, a deeper realization, that the two have to somehow be in a kind of coherence. The two functions have to be in coherence. And that at the end of the day, enforcement, it's not really all that important to hard normativity. What we have to have is the ability to sort of move back and forth between hard versions of normativity and a sort of softer consensual for that arise out of negotiation and discussion. And that's probably, in my view, what's most important about WTO law going forward, that we will reach transformative solutions going forward as we have in the past on, for example, access to medicines. We have not done that in COVID. On the COVID waiver, we have not done that in a range of areas, but there have been some useful developments in, for example, fishery subsidies.
Thank you.
I think I really touched upon the point that you asked. So I'll just respond to a couple of comments that was made by Professor Cotier. I do understand and the value of panels that it does have, and I don't want to take away from that. But I do think some members do use panel reports as a stepping stone to appeal and reach out to appellate body reports, which is why and by some members, I think we know who those few members are. And that's why there's also a prevalence of some panel reports being appealed into the void. And hence we have these mechanisms that are trying to address the crisis in place. And but yes, I do understand the value of a panel system, and most other areas of international law don't have a two-tiered dispute settlement system. So I see the value of it. So thank you for that comment, and I appreciate that. In terms of the general question of do we see, how do we rethink, and in terms of normativity, I think there is an overall backlash against internationalism, and countries are mistrustful, and it seems unlikely that, I hate to be pessimistic, but it does seem unlikely that we're going to come together and cooperate on a variety of different issues. But I do believe as academics and as policymakers, we should push our governments to be able to do so. So thank you.
Thank you. We've got about 10 minutes left. So I think there are 3 speakers there. We've got no one from the offline who's coming up. So within the 10 minutes framework, as I said, the gentleman right behind Thomas Cotier, and then the gentleman in front of you. And then I think you were the last. Yeah. Okay, go ahead. So, yes. Okay. Thank you for being a gentleman.
Thank you. Thank you very much. Good afternoon. I'm Umberto Celli from the University of São Paulo, Brazil. So I appreciated all the comments and presentations you made, but Chios, I think I pronounced it correctly. I really enjoyed your presentation because I totally agree with you, right? I think that there is a word called precedent or jurisprudence constante, and this was one of the reasons the United States used it to block the function of the appellate body, right? But I don't think there is any other way to avoid fragmentation, as Ronjini perfectly pointed out, without having, you may not call it precedent or jurisprudence constante, but there must be coherence in the decisions. No problem with using prior decisions and base your decision. If there is a prior decision which is very similar to the one you are assessing, no problem in using this. The International Court of Justice does this, we know this. So I think that this is an idea that, in my view, is still on the table, but I wonder whether it would be viable to propose this, because we know that there are countries like the United States which will certainly block this, right? So my question is, do you think it's really viable to propose this at this point in time? Oh, yes, yeah, or call it jurisprudence constante or precedent. I don't care. I think that this gives predictability to the system. To be very brief, I wrote a book. Unfortunately, it's in a very exotic language like Portuguese, right? I'm speaking not far away, spoke not far away from here, right? But I did the research on local content requirements. And my conclusion, my findings were that the decisions were very coherent in condemning the use of local content requirements. And prior decisions were used to justify the other decision, so on and so forth. So this is very useful. I think we should not forget this idea. But the question again is how, to get back to this idea, to propose this, do you think, is it viable? So.
We have 6 minutes left, and I've got 3 more questions. So would you like to answer a question or should it be done offline?
Just very briefly, I think that very good answer that I might have given in my remarks to you, and that's that I think we have a lot of law that has been developed in the last 25 years, and it will help us in the form of an acquis to move forward in the system, and that in the meantime, it's best to leave this very sensitive question perhaps undefined, and that the rational ability of panels to make an objective assessment will be what will guide the system ultimately. We see, for example, in the paper that I submitted, we see in international investment law that there's very little sort of overarching requirement of coherence from one arbitral award to another. And I'm suggesting that perhaps WTO decisions might evolve in that direction. That's what I mean in my title by the idea of possibility, without necessarily everything sundering and becoming very, very difficult to reconcile. What does this present? It presents what we refer to in the English common law as a wilderness of single instances, the possibility that we might have a huge variety of different decisions, but the decisions themselves become very, very fact specific. And that's where I would sort of see things going. It might be possible to have an interpretive decision or interpretive declaration by the membership, but beyond that, I'm not prepared to move at the moment. So.
Thank you. Sorry, I think we just need to entertain the audience. So we've got 3 persons right in front of me, that gentleman there, and then you have to your side, and then we've got one by Professor Greg Sheffer, and then we'll come to a close. So you've got 5 minutes. We could extend into the break time, but I'm just being mindful of that. So within that 5 minutes, please share your comments. Thank you very much. The gentleman right in front of me.
My name is Fernando. I'm from Federal University of DC in Brazil. And most important, I'm a political science. I'm not a legal scholar. So I think that some an issue that we should address to these matters here is about power and about the geopolitical confrontation between the United States and China. And when I will try to speak very fastly, I want to talk to James Losari, and perhaps it could help with answer from Ronjini and Chios Carmody. What are the political space for real mediation on any other kind of mechanism that deal with United States and China? Perhaps we are talking a lot of new ways to develop and make WTO works, but in a decoupling way. There is something that will be addressed for the United States and China outside the rules that will be arranged by power, and another thing that you address it for the rest of us, that you comply with the WTO obligations. I want to read a little about what you think about the geopolitical confrontation of power in that theme. And for Ana Perez, as a political scientist, I'm very interested in those discussions about incremental institutional change that make very little changes in times, but big mood changes along the way. But what was not clear for me is that you were talking about something that was unintended, that the change was doing by the actors that were trying to exercise their space in the WTO, or you are talking about planning small changes that we will sit in a place and arrange. We cannot change everything, but you can arrange piece by piece. And I think it's not something that's reasonable to be done. Perhaps that change that is not planned, the spontaneous change. It's not spontaneous in the ways that is natural, but is the actors doing their work and changed the way by drift, by conversion, by institutional displacement, a lot of concepts in political science that was developed to understand this kind of incremental change during times.
Thank you.
Thanks.
I would love to share this once, but in the interest of time, I think this will be done during the break. I would like to actually take the questions coming forward. So
Fantastic. First of all, I'd like to thank everyone for their contribution. Fantastic talks and presentations and the questions. My question is basically on the precedents question and on Guy, and 3 points and my esteemed colleague from Sao Paulo more or less touched on it. Number one, aren't we going back to the legitimate expectation model really? Aren't we going back to the legitimate expectation model really by following what you're suggesting? That number one. Number two, can we really afford to leave it undefined like that? Can we not just follow what Thomas mentioned and the civil law tradition of actually the policy and the legitimate expectations having a guiding light towards what we do? And three, is it really appropriate, sorry for the use of this word, to compare the international investment law to what we're doing here with the WTO, especially that we're dealing with one treaty, multiple treaties. We have a parallel panel now that is going on about the reform of international investment law and the issues with it. I can go on and on and on and on. And I don't think really it is the right way to say that international investment arbitration is going the right way. Therefore, we should leave it as it is. Apologies for the. Thank you very much.
We love to hear your views. Thank you very much. We appreciate that. We definitely go out here on. And last but not the least,
I'll just make two sort of comments, but we can talk about it. It's also for.
no, but if you want to raise something, you
Yeah, I
could.
wanted to raise two issues. One is the sustainability of the NPIA. With the United States not being a member, if one thinks about this, the United States has many friends around the world, and it has disputes with India, China, and so forth. There's 7 cases against China right now. It's easy for the United States to have Australia or another country bring a dispute under the NPIA, which is enforceable against China for a policy that the United States would like changed. But of course, it's not reciprocal because the United States is not a member. And I was just wondering in terms of how, love to have that discussion. And the second comment is just in terms of the NPIA, if I'm understanding correctly, the panel report is not on the WTO website, only the NPIA, only the arbitration report. So we see, I think, when I look right now, and the second question, the comment is, am I right that it's an arbitration which is not subject to adoption by the DSB? So there's not a DSB meeting. So again, in a sense, it's more to the extent that we're concerned about states losing control of the dispute settlement system, the NPIA actually represents a move away from a collective state engagement with the decision. So anyway, I just love to talk to people about this. Yes.
Very much. In the front, we've got a set of these questions. Sorry,
If I may.
you wish to speak? Yeah, we'll certainly. You'll be the last, but you can address it.
I know.
Yeah.
Yeah, thank you. Well, for those who do not know me, I'm Maria Pereira, Legal Affairs Division, WTO. Normally, we don't comment on these things. We are to be discreet, but yeah, but this is not confidential. I'm the actual head of the team that approves the circulation of documents under the WTO/DS series. So we had a bit trouble how to come up with a document, because of course the rules of the NPIA or the NPIA plus Turkey, so they will indicate to the party who's appealing through the arbitration or having recourse to arbitration in order for appeal, they needed to send actually to they need to send to the Secretariat an email with a notice of appeal, recourse 25, attaching and enclosing the final report of the panel in 3 official languages. The first one, it was a disaster. We had to come back for, because, and it was a disaster because our own fault, the Secretariat, because we never had a situation like that. And when we prepared the document of a panel report for the panel, we have a template that counts WTO/DS, the number /R. And of course, but that's the final report. For the Indian report, we put IR. But the final report, we don't put F. Now we're going to start doing that. But then what did you do? So at the end, when we agree with the parties on the first appeal,
And I said, okay, they said that you had to have the panel reports as attachments to the notice of appeal. So that's what they are. So you have the text of the reports within the system, but they are not legally circulated reports. And I'm talking about the legal term because a circulated report triggers the right of appeal. So we can't do that. See that, but for academics and so on, you could see the text of the panel report. Okay, then can we?
They're really engaging. In fact, I've not just got the panel, but even the audience here.
Can I make just one comment? I think because since India is a major party in the system, I mean, I completely echo the feelings of Professor Gregory Schaefer. So the feeling is that within the system, some countries are actually some major players are outside the system, and they have got friends and allies. So what will happen if these friends and allies actually bring a dispute, and there is no way you can actually bring a counter dispute against those countries? That is one concern. And the second is actually regarding the panel process itself. Will it actually affect the integrity of the panel process? I completely agree with Professor Thomas Cotier that you don't have to necessarily go for an appeal. You can actually settle the matter even after the panel report is circulated. But will the MPA process actually affect the integrity of the panel process? So this was a question which I had in my mind, but because of the paucity of time, I didn't want to read.
The US is not in the EPA. The ICJ is living without the US. The ICC is living without the US. UNCLOS, above the sea, lives without the US. Of course, the US, for me, it's the most important state in the world. But to say without the US, it is not sustainable, I don't say it in this way.
Thank you very much. I just want to sum up in the sense that we've had a really good discussion, at least I think so, because it was just not a panelists bringing up their versions, their concerns, their perspectives, but also having to engage with the audience and the comments that came and to be put forward in the stage too. I wish to thank Mara Pereira for speaking when she would ordinarily not. So this is really great, where angels fear to turn up. And we've got also James commenting, which is really good. This is a great cooking pot. The broth is there, and the more you stir, the more you will see coming up. I want to thank all of you and just give this closing speech to the speakers for their perspectives, very nuanced and inviting comments, and the audience online and offline, and at the same time, the SIEL organizers, including Alejandra, who gave me a nod that we're over time, and we have to be very mindful of that, and also to Sophia in front, the other SIEL organizer, very, very crucial in terms of support to us. If you would please join me to give a round of applause to the panelists. I close the session.